Hello, my name is Emma and I am here with Victoria. We are both students at the University of Wisconsin in the Family Court Clinic. Today we will be discussing child support modifications. If you have questions about how to file a motion to modify legal custody, physical placement, or child support, please watch our previous video that goes into more detail about filing a motion and giving notice to the other party. But note that in a child support action, the child support agency is often a party in the action. Be sure to provide them notice of the filing, just like the other party.
The Wisconsin statute about child support modifications is found in Wisconsin Statute 767.59. The statute is quite long, but don't worry. Today, we will break this down for you and you will have a much better understanding of what is required to modify a child support order once we are done.
The standard for modifying a child support order is usually a substantial change in circumstance. The statute lists four situations in which a substantial change in circumstance is presumed, but this presumption is rebuttable. The first situation in which either parent starts receiving state aid or participates in Wisconsin works. Situations in which substantial change of circumstance is presumed is that either parent starts receiving state aid or participates in Wisconsin works. 33 months have passed after the date of entry of the last child support order. The payer fails to furnish a timely disclosure, or the court did not use the percentage standard when the order was established.
The statute also lists situations that may constitute a substantial change in circumstances that is sufficient to revise a child support order. The first is that the payer had a change in income. This does not apply if the order expresses child support as a percentage of income. The second is if there has been a change in the child's needs. Additionally, if there's been a change in the payer's earning capacity. The statute has a catch-all that says that the court can also consider any other factor they determine is relevant. So if you have a situation that doesn't fit into any other category we just discussed, you may still be able to show a substantial change in circumstances that will allow you to modify a child support order.
There's some important limitations that you should keep in mind if you are considering filing a motion to modify child support. The court cannot change the child support amount or arrears prior to the date that notice of the action is given to the responding party. This except to correct errors in calculations. Also, the court cannot refund or credit child support payments made prior to notice being given.
The form you will use to modify child support is FA 4170B, and here's a step-by-step guide to completing the form.
Okay, now we are looking at the form. At the top of the form, you will see you need to fill out what county you are filing in. You will then fill out the information of the petitioner and the respondent. On the right side, you will check the boxes of what you are making a motion to try and change. You will then see the to line. You will fill out the name of the person that you are sending this to, of the other party. You will not fill out the next fields that have the location and date. The court will fill those out on their own at a later time. Now you have a chance to expand on what you're trying to ask the court to change. The first section is to modify physical placement orders. The next section is for legal custody, and then section C is for child support. The next section is maintenance, and then there is a section for arrears payments. After filling out the fields saying what you're trying to change, you will have to give the court the date of the order that you are asking to be modified. And then you have to fill out this section 3 that will let the court and the other party know what substantial changes have occurred that are leading you to make this change. After filling all these fields out, you will sign and date this form, and once it's complete, file it with the court. You will also need to complete an income and expense form. Let's review that form together, FA 4138B.
We are now looking at an income and expense statement. Again, fill out the petitioner and respondent boxes as well as your case numbers. Section 1 is going to be where you're going to attach your proof of income. This is a statement reflecting income earned to date for the current year and a most recent W-2 statement. Sections 2 and 3 are general information about yourself, such as your name and your address, as well as for your employer. Section number 4 is for you to enter the name and relationship of all people that you live with in your house. Section 5 is a breakdown of your monthly income and monthly deductions. Make sure you fill out these boxes as accurately as possible. Number 10 and number 21 will have you add together lines 1 and 9 and subtract lines 12 and 20. That way you can come up with your complete monthly net income. Section 6 is your current monthly household expenses. Please try and summarize to the best of your ability the most accurate numbers. Section number 7 is whether or not you have assets such as vehicles and real estate with a total fair market value of $10,000 or more at this time. Finally, you will sign and print your address at the box on the bottom right, and then this form should be all good to go. And finally, after you complete these forms and file them, you will need to mail a copy to the other parent. Use this affidavit of mailing form to prove you sent a copy to the other party. This is form FA 4121V. We are now looking at the affidavit of mailing. Again, at the top, fill out the petitioner and respondent names as well as your case number. This next section, you are going to check out each of the copy of the following documents that you've included in the envelope. Make sure you make note of the date that you sent the envelope out, as well as the name and address of the person that you are mailing to. Before you do anything else, make sure that you take this document to a notary before you sign it. Get it notarized at the courthouse, and then you are free to sign and print your name, and then this document should also be good to go. Additionally, for all of these forms, you may also receive a fee waiver. This is form CV410A. We will now go over form CV410A together.
This is the fee waiver form. Like the other forms, you will fill out the county information, your name, and the opposing party. This top section, under oath, you are stating that you cannot pay any of the filing fees or service fees in this action. Be sure to check this box. Section 1, you will fill out if you receive aid from any programs listed. If you do not receive aid, skip this section and go down to section 2. Section 2 then has information about your marital status, your employer status, a summary of your income, and your expenses at this time. Do not forget that this form will need to be notarized. Once it's been notarized, you can sign it and fill out the other fields of information at the bottom. Then it's complete and ready to file. Just a reminder that the Child Support Agency may be a party and may be able to petition for a change in child support. They may also object to or support proposed changes to the support order. Thank you for watching this video.